Good morning, everyone. As the clock strikes 9:30 on a cold and gloomy winter's morning in Johannesburg, I'm very pleased to welcome our various participants and panelists to yet another webinar in the CDH Employment Law series. This morning, I'm honored to facilitate a discussion with CDH colleagues from Johannesburg in Kenya and guests from Gateley who are based in Dubai in London. To our South African participants, whilst the last couple of days have been overshadowed by the Employment Equity Act amendments and changes to our affirmative action law, the topic we're going to engage in this morning with our panel on workplace harassment remains relevant, topical, and pertinent. Evident from this is the close to 600 RSVPs that we've had to this webinar. So we certainly do look forward to the engagement this morning. Our South African participants will recall that in March 2022, that's a little over a year ago, CDH hosted a webinar on the introduction in that month. I think the specific date was the 18th of March 2022, to the introduction of the harassment code under South African law. And it's hard to almost imagine that was almost a year ago. Over this period, we've assisted a number of clients in dealing with harassment-related litigation outside of the workplace, obviously in the tribunals, i.e. the CCMA, bargaining councils, and in the Labour Court, and with various complaints within the workplace where harassment issues were obviously first being dealt with. We've conducted numerous investigations on harassment issues, and we've reviewed and at times also overhauled internal policies that deal with questions of harassment. So it's been a very busy year in the space of harassment law in South Africa. And before I get to introduce the esteemed panel, just a lay of the land in relation to how we intend for today to play out. We intend to run the discussion for 50 minutes and then take questions in the last 10 minutes. So please feel free during the program to post any questions to the chat, so we may either respond directly in the chat room. Alternatively, we'll pick up the questions in the Q&A slot. With that having been said, I am pleased to kick off with an introduction to the panel, and if the panelists would then come on screen. First is Tendai Jangara, a partner and forensic specialist, lawyer based at the CDH office in Johannesburg. I see Tebang Rapuleng is also coming. He's not on screen. We don't see him. He may have a technical difficulty. Tebang is a long-time colleague of mine. He's a partner also in the employment law department at CDH in Johannesburg. We've then got a partner in the disputes and employment team in Kenya, Desmond Odhiambo, and our very special guests from Gateley. There's Guy Gunyan, who's an employment lawyer based in London, and Tenji Moyo, who's also an employment lawyer based at Gateley in Dubai. Welcome, everybody. And thanks for making time to join the panel discussion on what I'm hoping is going to be a fascinating discussion relating to harassment law. Tebang, whilst we don't see you on screen for technical reasons, and only because we don't want to fall foul of any harassment laws and being told that we're harassing you, let's perhaps kick off with a question with you. South Africa has been formally into harassment now for over a year. So perhaps this is a basic question. How does an employer identify harassment in the workplace in your experience over the last year?
Good morning, Imran. Good morning, everyone. My camera is on my side. I'm left wondering and probably regretting not being an IT expert in a moment such as this. But to answer your question, the concept of harassment is not a new concept in the workplace. As much as we did not have a code that specifically dealt with harassment, we've always had a code that dealt with sexual harassment, but not specifically workplace harassment. but employees will describe tangible experiences of harassment without necessarily using the term or the language as now identified in the code. And this will be them using words such as insulting behavior, demeaning behavior, abusive behavior, which now, because of the code, such terms are now specifically codified and appears in the code. Now, in identifying what constitutes harassment, the code has essentially adapted the sexual harassment code and implemented it to the harassment code. In that, when you look at the definition of how harassment is defined, it's defined as unwanted conduct that impairs the dignity of a person. And that is the language that is quite very similar, in fact, one can say identical to the sexual harassment definition code. So as to how you go about practically identifying it as an employer, sometimes it will be the complainant coming forward to say, this is what I'm experiencing. Sometimes it will be bystanders, other colleagues saying, this is what we are witnessing. But sometimes it will call upon you as the employee, if you have reason to believe it might be an anonymous tip-off and so on, to conduct an investigation. Mm-hmm. So in a nutshell, that's how you go about it. Thank you, Imran.
And Thabang, the concept of harassment, I mean, sexual harassment has been I don't want to use the word dumped, but has found its way into the general harassment code. But the concept is a very wide definition, and we'll perhaps at some point in the conversation discuss the wide concept of the harassment definition with Guy under the UK laws. But before we get to that, Tenji, I've always, as a tourist to Dubai, been fascinated by employment law in that part of the world. Now, in the UAE, labor legislation is very recent. Just talk to us about the changes that have come about over the last period relating to prevention of workplace harassment, and how much protection does that legislation actually grant to employees?
So as you have correctly kind of set out, the UAE labour law, which governs the onshore part of the UAE, we're divided into various free zones, and there's different jurisdictions, which I'll talk about later. But if we look at the UAE labour law, which is the federal law, harassment is a new concept. The labour law was repealed and replaced. So we had a new law come in last year in February. And what we were delighted to see was in black and white protection against workplace harassment. So it clearly spells out that there is a clear prohibition when it comes to bullying, when it comes to verbal or physical, and quite interesting to see that it's even extended to psychological violence is the direct translation. So they're now even taking into account any kind of, mental issues that may arise from issues in the workplace. Sexual harassment, of course, is also clearly defined in the Labour Code. Prior to last year, we simply didn't have it in the UAE labour law. For very serious cases, we always had to, as employment lawyers, look and see what the criminal penal code said. But, for matters that weren't necessarily criminal cases, we were kind of at a loss. And I think the UAE really wants to position itself as not just a place where you come on holiday, but a jurisdiction where you come and work, So how are you going to attract top talent to the UAE if you don't have robust laws? So it's, fantastic to see that there is now clear recognition of bullying and harassment in the UAE labour law. And I mean, we'll talk about what the impact of that has been in terms of claims and cases that we're seeing. But it's very clear that it does clearly set out bullying, harassment, and as Taban said, yes, that would be anything that creates a kind of hostile, offensive work environment is what we see. And I also think that employees are now more aware of their rights, so they're better at capturing and recording the issues and creating evidence, if you like, than was previously the case.
So when South Africa adopted the code in March of last year, it was effectively for South Africa to give effect to its international obligations under the ILO. So it's interesting to see that Dubai, or at least portions of the Middle East, are following in suit in that regard. Tenji and Desmond, perhaps if we can just take it to Kenya. Firstly, I guess the question is there specific legislation or like there is in Dubai, or a code of good practice like there is in South Africa that deals with anti-harassment law in the workplace? First question. And if there is, or if there isn't, what sort of harassment sort of cases do you see play out in the workplace in Kenya?
Yes, thanks, Imran. Yes, so in Kenya, there is no legislation that expressly, legislates harassment issues, any anti-harassment legislation, so to speak. The only piece of legislation that covers harassment is on sexual harassment. So that is the only one so far that exists. And because of that, you find that predominantly the cases that end up in the labor court are cases on sexual harassment. And it may, I think also that explains, why other forms of harassment have not made its way to the courts, because, employers or employees do not have something to guide them on how to identify the other forms of harassment, things like emotional harassment. It's not as overt as physical harassment or sexual harassment. So it goes undetected, and people in the workplace are suffering in silence. So I think there is an opportunity for both employers and policymakers in the Kenyan jurisdiction to come up with a framework, that imposes a positive obligation for workplace harassment. Having said that, it doesn't mean that an employer can necessarily get away with it. You can infer an obligation from the existing legislation that all forms of harassment is prohibited, but it's just an implied obligation. It's not expressly set out.
So I like the concept that you used, Desmond. Kenyan workers suffering in silence, you said. So we know, Guy, that in the UK workplace, there's no suffering in silence, and that the law in relation to harassment has long been developed. So perhaps just talk to us about just the development of the concept or the doctrine under UK law and legislation.
Yeah, absolutely. And good morning, everyone. And thank you, Imran, again. To look firstly at when harassment came onto the statute books, really, for employment law purposes, we are going back to 1975 with the Sex Discrimination Act, which was introduced at that time. So you're not a mathematician, but that's almost 50 years on my reckoning that it's been in place. I think our terminology, though, listening to all of you this morning and how we use that term is different to the broader concept which you are using. And I say that because in the UK, in employment context at least, harassment is not a standalone claim. We can only use it if it links to another what we would term as the protected characteristic of which there are many, but essentially discrimination across a broad spectrum of different protected characteristics. So unless someone falls into one of those areas, there is no ability to bring a harassment claim on a standalone basis. And in a broader sense, what I think is still quite surprising is that if we link it to bullying in the workplace, but without a discrimination element necessarily to it, there is no standalone claim for that either. So we have no legislation and we have no code that deals with bullying and harassment in a broader sense within the workplace. And as you say, the UK population is not quiet in that regard, so it doesn't go unnoticed. But what it does mean is we are forever looking at more novel ways of trying to combat it. And in order to do that, what we've seen certainly over the last few years is going back to more what we would term as Victorian style legislation, health and safety in the workplace, which came about with the Industrial Revolution, and the obligation on an employer to provide a safe system and a safe place of work. And what we're now seeing is people using that legislation in a modern day era to say, you aren't keeping me safe in the workplace because I'm being harassed or bullied, and I can't rely on the Equality Act, therefore I'm going to rely on the health and safety legislation. So we're seeing that develop quite a lot, and bullying is quite a big issue at the moment all over the UK press, largely because of some very high profile political figures being accused of bullying and leaving post over recent weeks. But it's a different way of getting to the end result, but unfortunately no code as such. And the only other way in which we deal with it is to suggest that on a contractual basis, again going back to common law principles rather than legislation, to say that the employer is in breach of contract by failing to protect someone, but based on an implied term of the contract.
That's interesting, Guy. In relation to how employee protections are almost boxed in the UK with all of the developments around the globe, I would say. But Thabang, if we can come back to the South African context, just off the back of what Guy is saying, we've effectively in South Africa, and it seems to me was Tenji's explanation as to what the lay of the land is in the Emirates. Employees have self-standing causes of action to claims of anti-harassment in our law, and now it sits under the discrimination law, under the Employment Equity Act. So can an employee institute a claim of harassment outside of the workplace, which ultimately falls under the Employment Equity Act? What's your thoughts around that?
Yes, thank you, Imran. Well, the straightforward answer to that is indeed the employee can, but however, there should be a link between the employer and the employer, the employee's conduct. And the link sometimes can arise because of the consequences that flow from the employer's conduct or the standing of the employee within the workplace, within the employment relationship. And one will think of things such as, for example, year-end functions, where they happen outside the workplace, but it's an employer-initiated function, team building, particularly where alcohol is involved. That's where you'll find our human capital colleagues getting a lot of stress, because when alcohol is involved, there tends to be misbehaviors that will follow. One of the famous cases in South Africa, which went all the way to the highest court that deals with employment law matters, the issue there was, it was a workplace trip outside the workplace. It's a work trip outside the workplace. The colleagues having dinner, having wine. Post that, one of the colleagues goes to another colleague and says, would you like a lover for the night? Yeah. And those particular words went all the way to the LHC, which is the Labour Appeals Court. And the LHC found that such words do constitute sexual harassment. So that's a classical example of conduct that happens now outside working hours, outside the workplace, where now you are basically socializing as colleagues, can find its way back into the employment sphere. And there's many other examples that can be used. But in essence, yes, it can. It can, and we now have a case law to support that particular basis.
And Tendai, perhaps if we can rope you into some of this conversation, you must be bored with employment lawyers because we speak to you so often about so many of these sort of issues. But allegations of harassment by nature are highly sensitive. Just at a very high level, just give us an indication of how it is in your experience, and you've been doing this for a very long time, how these sort of matters should be investigated by an employer.
So Imran, investigations of these kind of matters really require a high level of skill, and that is bearing in mind the result that you need to get to. So I'll start with the result, which is getting to what the allegations are, seeing if they can actually be proven or not, and then charges can flow from there, which was where the employment part would come in. Now, we find very often that the persons who are tasked with doing these investigations will either be your HR people, who can be the right people, but the level of skill that is required really is understanding investigative procedures so that you can gather the level of evidence that can be used for these kind of matters. Now, the level of evidence in these matters would be on a balance of probabilities, we understand, but evidence is still required. So what do we do in these matters? We need to make sure that the persons who are tasked with doing it first understand the code themselves. So really being clear on the code, and then know how to actually do the investigation. So on a very high level, the investigation requires you to go in, speak to the victim or the person who has brought forward the allegation, speak to them in a manner where they can give you a full account of what has occurred. If they have evidence, for example, in the form of documents, of witnesses, it means getting very clear statements. And what that means is then you can corroborate what has been said. But as we know, in matters of harassment, of bullying, they very often happen behind closed doors. So it now becomes she said, he said, and the evidence becomes difficult. Now, what that means for the people who are investigating is that you need to be able to ask the right questions. Have the person who's bringing the allegation actually give you a very full account. And there are techniques that are involved in there. I obviously can't go into it immediately, but it's really understanding that to get to the point where you can actually assess whether the allegation is true or not, it's really going to depend on the process, so the statements that are required and the evidence. Now, who does this investigation? I spoke about, very often in organizations, this is tasked to the employment department, to the HR department. As a rule of thumb, yes, you can use your people internally. Again, they need to be trained in the code. Your policies need to be very clear in terms of how investigations are done. They need to be very clear in terms of the types of harassment. And I know Guy spoke about, not having a code, and I think that makes it very difficult. When you have a code, you really can pin specific actions. But your policies within your organization are going to have to speak to this. They're going to have to be very clear, because you can then deal with the allegations. So internally, the persons who are tasked with investigations must look at the policies, and then they must apply good investigative procedures. You have the option of also getting external persons to come in and conduct the investigation. Now, it's also important, again, if you're going to use an external party, they must be aware of what the law of the land is, because they need to apply the same when looking at the allegations. And then they must also be aware of the policies that the organization has. So really, Imran, it's understanding the governance structure that's in place, and then from a practical process level, knowing how to ask the right questions, how to gather the supporting evidence, so that you can get to the end where you have a clear case of whether harassment has occurred or has not occurred.
So on the back of that, and perhaps let me relate my experience. And before I do that, maybe here's the confession. So it's a confession to Desmond, Tenji, and Guy. South Africans don't like particularly working in December. That's the time of year South Africans don't want to work. But I get called in on a frantic matter at the end of last year to convene a disciplinary inquiry in relation to a matter I know nothing about, obviously, and told you need to come and convene an inquiry. All I'm told about it's a harassment matter, and I'm faced with the matter, and a lot of what you said actually, as you were speaking, brings to mind what had happened in that case. I was asked to chair the internal investigation as an external chairperson. This was a harassment claim that was probably, I've not seen it. It's a textbook claim of harassment. An intern, female, lesbian. She was about 25, 26 years old at the time that she comes into the workplace. She's mentored by a very senior employee who's got many years experience in the business and in the industry. He's about, I think he was close to about 60 years old. There's allegations of cyberbullying. There's allegations of mobbing. There's allegations of he was in a lesbian relationship. When I say textbook, everything that the code kind of envisaged was in the facts of this case. As it came to me, and I looked at this and I said, "Wow, this is something you'd think you'd be put into university students." But what was classic about this case is that it had gone already to the CCMA and come back to the employer. And the reason is there was already a claim instituted by the employee against the employer for discrimination, because she alleged that the employer did not properly investigate the matter initially. The CCMA found in her favor, awarded her 12 months compensation for discrimination. So she achieved a R500,000 rand. That was her full remuneration for that year on the discrimination claim. The CCMA directed that the matter come back to the employer with an external person who had to chair the matter, who had to be a lawyer. That was the CCMA ruling. So when the matter came to me, you could see everything that you said had just played out in that matter. So the matter wasn't properly investigated. There was no sensitivity in the investigation, none of it. And needless to say, it took a day and a half to bring the matter to an end. And by the end of the first day, this employee ran out of the inquiry, nowhere to be seen. And within a day and a half, the matter was brought to an end. So I got to the beach in December, effected the termination, and I was told by the employer that there was no claim instituted thereafter. But it's an indication of how things can so quickly go wrong and need to be mitigated by an employer, especially in an environment where there is known harassment, and employers need to do a lot more in order to avoid claims rising. So everything that you say has lots of it resonates quite well in practice. Then perhaps, Desmond, if we can come back to you just with all of that being said, perhaps not specifically related to Kenya, but just as a general concept, and with your experience, why would you say that eliminating harassment could form part of the risk and compliance agenda of any organization?
Yeah, it should form part of the risk and compliance agenda for two reasons that I have in mind. The first, because there's a legal obligation in various jurisdictions. I mean, in some jurisdictions, there are express legislation that have been put in place to prohibit harassment. In other jurisdictions, like in Kenya, the legal obligations arises from an implied obligation, for instance, from the Health and Safety Act to promote the general safety and well-being of the employee. So an employer who fails, to adhere to that obligation and to take positive steps to fulfill that obligation, then risks legal sanctions. Some of the legal sanctions could be even criminal sanctions. So, for instance, in Kenya, if you fail to have a sexual harassment policy, that prevents or deters sexual harassment, then there's a criminal sanction. If you have more than 20 employees, then there is a criminal sanction against the employer. The employer can face up to 3 months in jail for failing to have a sexual harassment policy in place. So one is the legal obligation. That's the first reason why it should be, employers should take it as part of their risk and compliance. Secondly, which is also a growing trend, it's also an ethical obligation. And the ethical obligation arises, for instance, from the ESG principles. So one of the ESG principles is that employers should, have an obligation to be socially responsible with their own employees. And you find that, in the market that, organizations and people, do not want to, are increasingly demanding that the people they do business with should be people who are socially responsible. So both in the community and internally. So, you have to consider now what kind of labor practices are you promoting in your own organization. So that forces then employers to really take steps to come up with policies that would deter and that would investigate incidences of harassment, because there's a real reputational risk if you do not have that, and there's also a financial risk to some extent, because it means that for organizations that are probably seeking funding and they are wanting in that respect, they may be disqualified for getting funding because they're not ESG compliant. So I think that would probably, force many more employers, to take it seriously as part of their risk and compliance procedures.
Yeah. I like the fingering on the ESG angle. I think that's an area of focus, and one that's obviously going to develop he's already risen on the agenda, but he's certainly going to develop in years to come. So I think that's a very interesting angle, and one perhaps a takeaway point for all of us from this here in relation to why law side ESG is going to be, that this becomes a part of an ESG agenda for corporates going forward. And
absolutely. And sorry to interrupt. Even just to give a practical example, I mean, one of the multinationals in Kenya in the tea industry was cited for overlooking reports of sexual harassment from their organization, and a journalist took up the issue and reported the matter and took up the matter with the customers of this multinationals abroad in the US and in Europe, and the consequences of that was some of the customers indicated that they would withdraw their business from this multinational, and it's worth millions of dollars. So it's no longer just a principle that is sort of hazy, but it's something that people are taking seriously.
Yeah, well, that's interesting in relation to the consequences outside of a formal litigation process, in respect of non-compliance or a failure of an employer to effectively manage harassment claims. But then, if we were to bring it back into the litigation context, Tenji, in your experience with the recent developments in the UAE, have you seen a rise in claims in relation to workplace bullying or general harassment?
Yeah, we have. So whilst before people were making complaints and inquiries, because the law was unclear in terms of, whether it was recognized and prohibited expressly in the law, and there weren't any claims. But now that the new UAE labour law is in force, we are seeing increased number of labour claims being filed. What we haven't seen, or as far as I'm aware, what I haven't seen is any judgments in the year that it's been enforced in favour of employees. So I think that is, something that we are looking at. Of course, when it comes to bullying, harassment, which is always linked, as Guy said, to discrimination, companies are more willing to take an approach to settle such matters, right? So a lot of the cases that we've had have settled because corporates are concerned about their corporate responsibility. You know, Desmond spoke about, ESG and the S. So what you don't want is you don't want negative, press, journalists picking up such cases in the court. So a lot of the time you find many companies, when a legal notice or a letter before action goes, that there's a more willingness to settle such matters. As a result, it's not that the claims are not coming, it's because they're not going the full extent. What we do have in the DIFC, so the UAE is got common law jurisdiction and a civil law jurisdiction. And actually, next month we are testing the law in our courts in the common law jurisdictions. We have a 5-day hearing listed on this matter to actually test discrimination in the DIFC courts. And again, I have been in this jurisdiction for 12 years and all the matters have settled. And it's expensive. Employees just don't have the money to take these matters on. Litigation is expensive. But we are now seeing that, some employees are willing to go the full way, pay for it. And now, even though we are relatively baby jurisdiction, we're hoping to have, case law, which we can rely on and advise on. So yes, we are seeing a trend that way, and watch this space.
So litigation is expensive for an individual against a corporate. So as you make that point, Tenji, I'm just thinking because I was not too long ago involved in a matter which had also settled in relation to harass more than one harassment claim actually, and it got me thinking in that matter. And I'd like to hear your views, Guy, Tenji, Tabang, Desmond, on this, considering I've got you guys all around. I was about to say around a table, to have all of you guys around here early in the morning, and I don't have to pay for this advice. What are your views in relation to a class action? So let's use Desmond's example, right? In class action instituted against an employer for harassment. My own view is that I think there's potential for those sort of claims in time to come. Can I give you the short end of the straw on that one? And what's your views on a potential class action on harassment?
It's expensive and good for the lawyers. I think is probably the starting point there. Obviously it's a very expensive way of progressing matters. It's a way of sharing costs for claimants if they're not otherwise insured and they're acting individually. But it's difficult to marshal a large number of claimants. So where we have dealt with those claims in the past, what we tend to do is try and look for test cases within the sample that we think can cover the various avenues. And that's something that you're looking for a degree of cooperation with corporate involved as well to set the parameters of the claim. And then the judicial system will support that process as a means of limiting the costs ultimately involved, and obviously the court time as well in their own interests as well.
So I must apologize, Guy. I fell off the network for a bit, so I didn't get to hear a lot of what you said. But just, and I'd be interested in hearing it, but I'll pick it up. But perhaps because we are going to run out of time very quickly. Tenji, on your side, your views on it?
So we're unique in the sense that we don't have any trade unions or collective action. So we have had employees come as a group, but it really will be individual action. So a similar approach to what Guy has identified. If we look at the onshore under the UAE labor law, we actually have long limitation period. We have 1 year. To bring a labor claim. So, we're not pushed for time as we are perhaps in other jurisdictions such as the UK. So you can, identify a lead claimant, see it through, and then see if you can resolve it that way. But there is no class action or strikes as you would find in other jurisdictions.
That's interesting. Tabang, just what do you think about the possibility?
Yes. Imran, I share your views on this one, that there is definitely potential for it. It's one of the areas that I think they are underexplored, particularly in our country, especially when it comes to such claims, harassment and so on. But if one looks at in the field that insofar as occupational health and safety cases are concerned, it has been explored in those fields. And it's one wonders why, when it comes to employment matters such as harassment, is underexplored. But when you look at internal, even before you go external, you'll find that internally you'll find group grievances where employees are bringing a group grievance claiming harassment by a manager or a fellow colleague. And when disputes are referred to the CCMA, external tribunals such as the CCMA, we've seen disputes being referred by a group of employees where they are unhappy, but we are as yet to see it now being taken into now formal litigation where they bring it in the form of a class action, more especially claiming damages of some sort. It's one of the areas that I still feel they are underutilized. Probably we're going to see more and more of such actions with the with the arrival of the harassment code and more training in topics such as this one, the harassment code and so on. We're likely going to see an increase in it.
Well, Tabang, perhaps with less litigation against the road accident fund, personal injury lawyers will now move their focus to the workplace. Desmond, your quick thoughts on that? I see we are quickly running out of time.
Yes.
And I want to pick up another topic with Tendai and then perhaps go around for final views.
Yes, it is possible, and there's actually an ongoing class action against James Finlay in the UK from workers in the tea industry here in Kenya, where the workers have sued James Finlay in the UK courts, for accusing them of subjecting them to repetitive manual labor, under long hours with no breaks. So I guess the personal injury lawyers here have taken their practice to the workplace, to the employment practice, as you've said, Imran. So it is possible and it is happening. Yeah.
Interesting. Tendai, perhaps we haven't spoken a lot about cyberbullying. We know that that's I don't want to call it the new frontier, but that's the new world. Let's just talk about investigations and how do you manage cyberbullying, because that happens so often.
Yeah, Imran, very interesting area. People hide behind technology. And, with bullying, if it's a face-to-face or happening in the workplace, very often you'll know who's harassing you. But when it comes to cyberbullying, it could be the person sitting right next to you and you just will not be aware. It's that anonymity that our cyber and our tech provide us with. So we see a lot of incidents of cyberbullying happening at the moment. We're investigating a lot of them. So where employers need to position themselves on this is having, again, very clear policy on the issue of cyberbullying, making sure that employees know that it will not be tolerated, and then having the capability to investigate. Now, very often organizations themselves can't do the investigation. So what's required is having a service provider who is able to do it, who would then be able to go through the process. If an incident of cyberbullying occurs in your organization, first thing is that employees must be aware that they can report it. So they don't need to know who the harasser is. They need to bring it to the organization. So very often it happens via email. It can happen via WhatsApp. It must come to the employer. Employers must then be ready to investigate. And that's where the service provider comes in. What happens a lot is employers want to refer these matters to their internal IT departments. IT departments are not forensic or digital investigators. They cannot handle these matters. It requires experts. It requires a team, in fact. So you have your digital forensic people who can look at the systems, try and trace where this information is coming from. Yeah. But then you also need your investigators who I spoke about earlier, who are then able to conduct the full investigation. So it's not just about the cyber part, not just the technology, it's harassment itself, as we were talking about the code and the different instances that happen, it's bullying. So that is an investigation that has to be done from the practical perspective. And I'll bring it to, you know, when you're then conducting those interviews with the person, with the victim who's received this or has suffered this, this bullying, you need to then be able to ask them the questions which can point possibly to who the perpetrator is. So it needs to work in conjunction. Your cyber side, your digital forensic specialists will look at how it's come in, possibly trace where it's come from. But the person who's been victimized must also be engaged so they can give you an understanding of the situations they're in, any challenges they're having with people within the organization. Another important point to remember is that people get harassed at work, even by people who are outside the organization, and employers need to think about how they then handle that. If a person is being harassed internally, but it may be someone outside, we find that employers, in the best interests of their employees, then do get involved. You can't leave your employees and say, well, you know, we think this might be your personal matter. No, if it's coming to them and let's say possibly via their work email, it becomes a workplace matter. So a lot to think about when it comes to cyberbullying, a lot of considerations, but employers must grapple with this and must have the policies in place, the training in place, and the services to actually engage and investigate when it happens. Thanks, Emma.
Thanks. I'm going to be unfair to you. I'm going to say to you, you're under immense time pressure, but I've got two burning questions I've got to ask you, and we've then really got to wrap it up. So the first, what's fascinated me is gagging, let's call it gagging agreements, confidentiality, NDAs. So post the Me Too campaign, we know that there's been a fair bit of development in that field, both in the US and particularly in the UK. So in harassment claims, my first question is, where does the law currently sit in relation to confidentiality provisions? That's the first question. And then my second, when I'm being unfair to you, is your closing comments, and then I'm going to ask everybody else in relation to their last views in relation to what employers should be doing, knowing where we stand in the current environment and where the laws are in relation to anti-harassment. Do you want to take it away, Guy?
Yeah, sorry, I think having trouble with the technology there a little bit. Apologies for that. Yeah, looking at NDAs, I guess initially there's been a lot of it in the legal press in the UK, and there are now specific guidance, government guidance and codes coming in relation to public sector employees and workplaces where the employer, public sector employer across the spectrum of whether that's health or government, are not able to insert within settlement agreements where they reach a settlement a blanket gagging clause or NDA. So that's just a government restriction. It's yet to be provided out more widely into the private sector, but we suspect that that is something which will come because there's a lot of pressure. And so I'm conscious of the time, but professional rules as well have come in for lawyers in this respect, because our professional body has now introduced restrictions to make it a professional misconduct issue for lawyers to include wide-ranging gagging clauses within a settlement agreement for particular reasons. There are exemptions and national security and various things, but if we include a gagging clause, we have to make sure it's properly justified across a number of reasons and sectors.
That's very interesting, and I suspect it's a matter of time before that ripples across other jurisdictions.
I would suspect so.
Yeah. And then whilst you've got the microphone, perhaps just your closing comments. Okay.
Yeah, closing comment. I'll take the liberty of having two. The first is just to touch on criminal elements, because we obviously have that as a extreme form of bullying and harassment. Then there are criminal jurisdictions which will overlap and come into the workplace, so it's something the employer has to be mindful of. And again, touching on Tende, needs to be good processes, good training, good policies in place to deal with all of those issues. And the last thing, just for me to touch on, is being mindful that when we talk about bullying and harassment, we typically talk about senior or more senior employees bullying their colleagues, bullying subordinate staff. And what we're seeing increasingly is a trend where actually a team may get together and actually bully their line manager with a view to making the line manager look bad, because they miss deadlines, they miss timescales, they misinterpret instructions. That is an upward bullying as opposed to a downward bullying and harassment, but sometimes harder to identify, but certainly something to watch.
Yeah, fair enough. Tendai, on your side, perhaps by way of a closing comment, I see it's a very interesting question in the chat about non-training of employees in relation to conducting investigations, and the person says the processes are often fraught with bias, judgment of the parties, shoddy processes, lack of confidentiality. I've experienced some of that. What's your experience in on that front?
Absolutely, Imran. So best bet, and I think someone had asked a question about whether it's good to have the investigations done internally or to get an external party. Best practice, I would always say, is get an external party and make sure that they are legal. So legal practitioners must do this. The reason you want to do this is to eliminate all of these challenges. So your bias, very often, if it's internal, it's referred to either your employment team, your HR people who are also responsible for talking to people about their salaries. So, it becomes a mix of issues that are then put on people who are supposed to investigate, and having that separation between your internal people and then management of, again, very sensitive matters is very important. So those biases do exist. There are pressures from senior executives in an organization on the people who are supposed to investigate. So it's not likely that you'll get an independent investigation. So really, to end off, I would say make sure your governance processes are in place. Make sure you have your policies which speak to how matters of harassment are dealt with, including your cyber issues that we touched on, and then make sure that you have a good investigation procedure. If you're going to do it internally, make sure you have people who can demonstrate independence. That's going to be very important. Yeah. If, for example, you need to go through a process. Best practice, have an independent body that you can refer the matter to, have it investigated. Legal privilege is also very important for these matters. You want to have that legal privilege. So rather use your legal independent people to do it. Thank you.
Or your internal legal team or person specifically designed or trained to deal with investigations. I guess it's a mixed bag, and depending on your area of risk in relation to a particular matter.
Absolutely.
Then Tendai, Tenji, there's a question in relation to the UAE, and the question is, does a company in the UAE need to have policies based on harassment and discrimination? That's the first question. And is training required for management on the same, meaning in relation to those policies, so that they can prepare to handle such situations?
Yeah, good question. So with the new labour law, they have said that any companies with over 50 employees should have a grievance and disciplinary procedure. So we're recommending to all our clients to make sure they have a staff handbook, which clearly sets out all the internal procedures, which deals with bullying and harassment and so forth. Absolutely. And those are just best practice principles anyway. In the other jurisdictions, such as the DIFC and ADGM, which are common law jurisdictions, it isn't there in black and white. However, it's best practice, because when we know when a matter gets litigious, the first thing we ask for is, what are your internal policies? What are your procedures? That's where we start off, and that's what's going to support the points that Tendai has just articulated. Just really in terms of my final points, it's really important, I think, to emphasize the training aspect. And the training aspect really, in my view, shouldn't be limited to HR and senior management. The best organizations are actually the ones that are bringing in training and harassment at all levels. We've recently gone into an organization and we have done training and harassment all the way down to the security guards, right? To talk about all the day-to-day experiences that they face and they deal with. Because what we need to understand is an organization is not just the board and senior management, it's the people. In the UAE, what's unique about us is one organization can have 50 nationalities very easily. And because of that, we automatically have cultural differences, and then they become bullying, harassment claims because people have different sensitivities. So it's therefore really important to have these training and open dialogue about, you know, what's offensive to me, because as we know, harassment is really quite subjective. At the end of the day, it's how I feel. If I feel humiliated because you commented on the way I look, that might be, standard in a different culture. So we really kind of promote that training. And actually, since the law has changed, there has been a spike in the request for that. And I think if organizations become more proactive when it comes to that, if anything, it's a good defense for an organization to say, actually, we are a zero tolerant organization and we've done this training all the way through, so everyone knows exactly what the policies and procedures are. How many organizations do we have where people don't even know where the staff handbook is? They haven't seen it. So it's all well and good to have a good policy, but if no one's seen it, it's really not worth the paper that it's written on.
Fair enough. And then, Desmond, would you agree with that? With those views generally in the Kenyan context?
Yes, absolutely. I think it's time that employers now became proactive and came up with policies to prevent workplace bullying, and especially so because at the moment there's no express, definition of what amounts to workplace bullying, but it can be inferred. So it behoves on the employer to take that extra step to be proactive and not to consider other forms of harassment as, on the lower end of the spectrum, verbal abuse, something that you don't really pay attention to. I think it's becoming now as just as serious as physical or sexual harassment, because it impacts on the mental health of the employees. So it should really be at the forefront, and positive action needs to be taken. They need to engage experts to do audits and work with people who would help them come up with best practices for their workplaces.
Then, Thabang, you've got almost the end of the closing mic. Under the South African law, a defense for an employer facing a claim of harassment is that there has been training of employees. In your experience, how effective is that sort of a defense for employers?
Well, it basically will depend on the extent of the training and what were you training the employees on. I'm aware of one case, I'm struggling to recall the name, where the mere fact that you had not trained employees on the reporting channels, you told them what is sexual harassment, how it can arise, but you didn't train them on how you go about reporting it. Yeah. That worked against the employer. Yeah. So it's quite important. And just one point as my final comment, Imad, the training, taking into account the broad scope now of the harassment code, should not even be confined to our employees. If you have people who are seconded to your premises, who will be interacting with your employees, you need to ensure that those people are trained. If they are not trained, then you as the employer must then take up the obligation to train them, because they too can be a cause of harassment, and that extends to service providers, clients, and so on. Thank you.
So it leads me to thank our panelists, Tendai, Guy, Tenji, Desmond, and Tabang. This was a great, insightful, I think, a useful session on a topic that's very topical and clearly, I would say, multi-jurisdictional. So people are people all over the world. These things happen in different workplaces. Employers in different jurisdictions just need to be very alive to where their risks are and what they need to do in order to protect employees in the workplace. Much appreciate every one of you taking the time. To our participants who are on the call, thank you very much for making time to join us on another CDH employment webinar. We're going to be hosting a webinar on the Employment Equity Amendment changes towards the latter end of this month. Please join us for that. And my very final comment is, if there are any specific questions that you've got the email addresses of the various panelists on the screen. Please feel free to direct emails directly to them. I can assure you that I'm told by our marketing team that the photograph right at the top is Johannesburg when we have light. The rest is London, Dubai, and Nairobi. So I can assure you the email addresses are correct. I'm not too sure about the Johannesburg photograph without light, but please feel free to contact us. Thank you very much and enjoy the rest of your day.